Sources of Constitution. Features of Indian Constitution. Sources of the Indian Constitution. Sources of the Constitution of India are diverse and many. These sources are both indigenous and external or foreign. The founding fathers made it very clear that they are not making a complete departure from the past but building on the existing structure and experience of the institutions that are already established. The Constitution of India evolved through the interaction between various demands of representative responsible government institutions and the small dose of constitutional reform granted by the British from time to time. Sources of Indian Constitution. Indigenous sources. 75% of the provision from Government of India Act 1935. Organization of Village Panchayat, etc. External or foreign sources. Constitution of various countries like Ireland, USA, UK, Canada, USSR, etc. Indigenous sources of Constitution. The organization of village panchayat under the directive principles was influenced by ancient Indian institutions of self-government. The demand for fundamental rights were put forward at the Madras session of Congress in 1927. The Karachi Congress resolution of 1931 included features of both fundamental rights and fundamental duties. Nearly 75% of the Constitution can be said to be a reproduction of the Government of India Act of 1935 with suitable modification. The most notable of the provisions included under the Constitution are the following: provisions regulating union and state relations, declaration of emergency, office of governor, public service commission, etc. Foreign sources. Besides the indigenous sources, the Constitution Assembly borrowed several features from the foreign institutions, which included: first, Ireland, concepts of directive principles of state policy, method of election of president; USA, written constitution, independent judiciary, judicial review, preamble, fundamental rights, president as the supreme commander of armed forces; United Kingdom, the President of India, like the Queen or King of England, is the nominal head of the state, post of the Prime Minister, parliamentary system with ministerial responsibility to the legislature. Canadian Constitution, provision relation to union and state relations, distribution of power between the union and states, and residuary power to the union government. Silent features of the Indian Constitution. Size of the Constitution. It is the lengthiest constitution of the world. It is very comprehensive document. Originally it consisted of 395 articles and 8 schedules. Subsequently, amendments made changes to the Indian Constitution. At present, it contains more than 470 articles, 12 schedules and 25 parts. The new articles have been inserted in alphanumerical form. For example, Article 21A, which provides the right to have free and compulsory education. Reasons for the length of the Indian Constitution. It includes many matters which could be the subject matter of ordinary legislature or administrative actions. It happens because around 75% of the provisions of the Government of India Act 1935 were reproduced in the Constitution. The Constitution makers did not want to leave certain matters to doubt. The Constitution makers borrowed a large number of provisions from several foreign sources like the US Constitution, Canadian Constitution, etc. There was also a need to have provision keeping in view of complexities and diversities of the Indian situations, leading to several special and temporary provisions for certain regions of the country or classes of the people. For example, special provisions for scheduled caste and scheduled tribes and provisions for Jammu and Kashmir as well as provisions for the backward region. Detailed provisions have been provided for center-state relations. States don't have their own separate constitution like that of the USA. That is why the Constitution of India not only included the Constitution of the Union but also of the states. The Constitution of India provides a comprehensive set of fundamental rights, directive principles of state policy, etc.